So good evening. My name is Shannon Ayers, and I am the Collin County Education Division Lead for Citizens Defending Freedom, or CDF. I'm here to follow regarding the recent proposed rule change to Title IX that broadens its language to include sexual orientation and gender identity. This undermines federal law and the legislative authority of the United States Congress. While some organizations have followed the misleading guidance of the Department of Education's 2021 Notice of Interpretation following President Biden's executive order on the Supreme Court ruling in Bostick v. Clayton County, both have been significantly misinterpreted, as it was made clear by the court that the latter was a Title VII issue that did not apply to Title IX or any other law. The Supreme Court in Bostick emphasized that sex-based employment discrimination was consistent with Title VII, but it was unconstitutional, but explicitly refrained from applying their ruling to Title IX. As such, this renders the Department of Education's NOI and the executive order null because it expressly contradicts Supreme Court precedent. If this wasn't enough, there have been a handful of cases further demonstrating the inapplicability of the Bostick ruling to Title IX issues. This includes a recent ruling out of a federal district court issuing a preliminary injunction barring the execution of the Biden administration's NOI and executive order from taking effect in 20 states, including Arkansas and Oklahoma. Separately, a federal district court in Texas affirmed that sexual orientation and gender identity are not protected categories because Title IX must be read in the original context in which it was drafted in 1972, where sex was understood to be biological and binary. A federal appellate court covering Florida, Georgia, and Alabama jurisdictions also found this to be true, ruling that a local school board's bathroom policy did not violate Title IX because Title IX conforms to an understanding of sex consistent with the societal understanding of sex at the time of its drafting. Beyond this, applying any directive that neither conforms to these recent rulings nor takes into consideration the necessity of receiving congressional approval before making a change to federal law is itself an unconstitutional act. In Bostick v. Clayton, the Supreme Court stated that the people's representatives are the ones who must amend Title IX, thereby making it unlawful for non-congressional officials, including school board members, to assume changes to Title IX in the absence of approval to amend it, a power reserved exclusively by Congress. I would ask that you consider this information before acting on the coercive tactics by organizations intentionally misapplying Title IX to push a political agenda. A serious consequence of this misapplication includes the erosion of student privacy stemming from the rights of students to use sex-separated facilities and to participate in sex-separated sporting activities. One final note, this rule change is currently open for public comment in the Federal Register until May 15th. Due to the federalism implications of this rule change, they are encouraging state and local elected officials like yourselves to review and provide comments.
Thank you so much. Appreciate you coming tonight.
Thank you.